Hi there, it's Thomas Leonard Ross. Welcome to Glasgow Advocate Talks. Had been my intention to follow up the podcast regarding the Peter Murrell case by answering some questions, but when I thought about it, we're near enough to the sentencing diet now that it makes sense to wait until sentence is passed. And then I can explain some of the aspects arising from the sentencing exercise and deal with any other questions which have come up in the meantime. The issue which interested me most this week was the sentencing of the Palestine Action protesters, the Filton Four, as they've become known. This was an English case, and not all the issues were immediately obvious to me. It did appear there was a degree of misinformation in relation to it. And so I thought it would be helpful if I was to look at the sentencing statement of the judge, Mr Justice Johnston, and try and correct some of the misinformation which is out there in the public domain. I'm not going to pass any comment on the fairness of the sentence. No doubt everybody's got their own view on that, but I'm really just dealing with some of the legal issues, because it seems that some people have, quite a lot of people, have misunderstood what happened, and clearly some people are trying to make political capital out of that. What I should say, and this could have confused the issue, there was an appeal in relation to an attempt to judicially review the government's decision to make Palestine Action a prescribed organisation under the Terrorism Act. This case has got nothing to do with that. It wasn't retrospective, and at the time when this offence was committed, namely August 2024, Palestine Action was not a prescribed terrorist organisation. So I can see why people might have been confused about that, but it's completely irrelevant. So please just put that issue out of your head. So what we know is that on the 6th of August 2024, the group of four people, three females and one male, that's important because it makes it easier to explain it, because the male was the only person convicted of a particular offence. So 6th of August 2024, they drove through the perimeter fence of Elbit Systems in Filton in a repurposed prison van which they had bought. They were each in possession of a sledgehammer, a crowbar, flares, a fire extinguisher filled with paint, and rope which was to be used for barricading doors. And over a 20-minute period, they damaged and destroyed technological equipment and a disabled toilet worth around £1.175 million. Now, I'll deal briefly with Mr Samuel Corner. He was convicted of what I would regard as a more serious offence, but actually his offence, it was only him who was convicted of it, and it doesn't have so much of a bearing on the issues. But I know people are going to come back and say, well, he was swinging a sledgehammer about and so on. So just to deal with that, he went in with a sledgehammer as the others did. He swung it at the first security guard, who confronted them, narrowly missing the security guard. And then when the police turned up, he swung it at PC Buxton when the constable was defenceless on the floor. That caused a minor injury. But then when Police Sergeant Kate Evans was on her knees seeking to arrest one of the protesters, he raised this sledgehammer above his head and brought it down onto her back, causing multiple fractures to her vertebrae. And by the time of the sentence, which was a couple of years on almost, she was still unable to return to operational duties. There had been a significant loss of earnings. There had been an effect upon her parents and her children, who fear for her safety when she goes to work, and clearly a great deal of pain and suffering. As I say, I'll tell you what he got for that, but actually it doesn't really have very much to do with the issues that I'm interested in, as I'll explain. So in England, I'll come back to how they might have been dealt with in Scotland at the end, but in England the judges are in a way under tighter control because they're bound by the Sentencing Act 2020 and bound by a number of sentencing guidelines. Traditionally in Scotland, the sentencing policy was really set by the Court of Criminal Appeal. We're at the early stages of sentencing guidelines in relation to specific offences in Scotland. We've got one for causing death by driving, we've got one for rape and serious sexual offences, but not for anything else at the moment. But in England, there's a whole number of sentencing considerations which the judge is absolutely bound by, and I stress that because if the judge had chosen to ignore these sentencing rules, the prosecution, the Attorney General, could potentially have appealed against the sentences as unduly lenient on a legal ground, namely that the judge had failed to apply the rules that he was bound by law to apply. And the principal one is the Sentencing Act 2020, which says that the sentencing judge must take account of aggravating factors. And there's a whole list of aggravating factors. The offence was committed on bail, previous convictions, that it was an assault upon an emergency worker or those providing a public service, it was a supply of drugs near a school. All those things need to be taken into account. But they include whether the offence has a terrorist connection. And if by law the offence has a terrorist connection, then the court must treat this as an aggravating factor. So we need to go to the Terrorism Act 2000 and to see what the definition of a terrorist connection is. And Section 1 of the Terrorism Act 2000 tells us that terrorism means the use of action where the use is designed to influence the government, and the action falls within this subsection if it involves serious violence against a person and serious damage to property. So I'll come back and look at those two tests, but before I do, before I leave the Sentencing Act 2020, Section 278 provides that in circumstances which were found to apply here, that there must be a further period of 1 year added during which the offender is subject to licence. I'll come back to that later. So the other factor which is relevant is the Counter-Terrorism Act 2008, and this provides notification requirements on persons convicted of certain offences. For example, certain offences under the Terrorism Act 2000, but Section 42 provides that they apply, the Counter-Terrorism Act 2008 notification requirements apply to an offence to which the court has determined under Section 69 to have a terrorist connection. And I simply add, before I go on to look at the facts, at the outset of the case and against the Filton 4, the prosecution asked the judge to determine that the criminal damage offence had a terrorist connection. This seems a pretty unusual thing. Maybe it's not unusual in England. I really meant in Scotland. I can't really think of a situation where the prosecutor would ask the judge to determine that before the case even finished, because it's relevant to sentence, and obviously if the jury had acquitted them all there wouldn't have been any sentence, but maybe there's a reason for it that I'm missing. But in any event, at the start of the trial there was legal argument, and the judge ruled that the alleged offence of criminal damage did have a terrorist connection. And when I come to explain the law in that, it would have been impossible, absolutely impossible for him to have come to any other conclusion, I think. But there was a reporting restriction, and the accused asked the judge not to lift that restriction, and it wasn't lifted on the request of the accused people. And I'll come back to that, but that's got some significance in relation to some of the comments which were made in the aftermath. So, in determining whether there was a terrorist connection, there were really two questions for the judge to consider. Firstly, was there serious damage to property? Well, as you've heard already, there was more than £1 million paid out by the insurers, so that was easily met as the test of serious damage to property. The second, was there purpose to influence the government? And Charlotte Head, in her closing speech, said to the jury that she was trying to end British complicity in war crimes. Leona Cameo, in her defence statement, said that the UK was allowing arms exports to Israel, and Fatima Rajwani said in her closing speech that she was sick of waiting for the government to act. So again, it would have been really difficult not to come to the conclusion that the purpose of the damage was to influence the UK government. So it doesn't seem really there was any other option open to the judge but to hold that the offence had a terrorist connection. Turning to the sentences which were passed at Woolwich Crown Court on the 12th of June 2026, I'm going to speak about the criminal damage principally. I'll mention the inflicting grievous bodily harm also at the end. But the maximum sentence for criminal damage is 10 years. And if we look at the way the judge went about it in relation to Charlotte Head, who was aged 30, he remarked that 10 years was the maximum. He thought that the starting point was 5 years, which is half the maximum. And he then looked at aggravating factors, which included the terrorist connection and the fact that they were trespassing at the time when they committed the offence, and some other aggravating factors. And he took the view that that took it up from 5 years to 7 years. But he then looked at the good character of the offenders and the fact that they believed they were doing it for the public good. And he took the view that took a year off. So it went from 5 up to 7 and then down to 6. So Charlotte Head, aged 30, ended up with 6 years, as did Leona Cameo on the same logic. She was aged 30 and she got 6 years. They both get a year additional licence, which I spoke of earlier, which really means when they get out, they're subject to recall to prison for a year more than they would have been if this had been a case without a terrorist connection, I suppose. Fatima Rajwani, she was only 21, so she was 9 years younger than the other two women, and the judge took account of that, and she ended up with 4 years and 8 months, plus the mandatory 1 year additional licence. Samuel Corner, the sledgehammer man, he was 23, and he ended up with 7 years and 8 months, and that was made up of 4 years for the criminal damage and 3 years 8 months for inflicting grievous bodily harm without intent. And also, so you get 7 years 8 months plus a year's additional licence. And they all were made subject to the notification requirements under the Counter-Terrorism Act 2008 for a period of 15 years. The judge doesn't really determine that. It depends on the length of the sentences which are imposed. So there was some reaction to it. I saw somebody on Twitter compare Justice Johnston with the judges who fell into line with the Nazi party in Germany in the 1930s. Clearly that's very, very unfair when you look at the sentencing statement which is available. He had his hands tied by the legislation and the guidelines. He set out in great detail. It took him 35 minutes actually. I think probably still available on YouTube. 35 minutes they explained every relevant factor. And of course, unlike Nazi Germany in the 1930s, all 4 accused can appeal against the sentences. Zach Polanski said it was a truly dangerous attack on the right to protest. Well, it's definitely an attack on the right to protest by hitting a female police officer with a sledgehammer or causing £1.2 million worth of damage. It certainly doesn't really have any relevance to somebody who's protesting in the normal way by marching down a main street with a placard. John McDonnell said they'd been sentenced for protesting to save lives in Gaza, and they had been sentenced on a terrorist ground that they were never convicted of by a jury. I wondered about that. He's right, actually, because the aggravation is taken into account at the sentencing stage. But I suppose it's also relevant that it could have been taken into account by the jury, but for the fact that the accused asked the judge not to lift the reporting restriction at the start of the trial. It's a strange procedure, which I can understand why the accused would not want the jury to know that the judge had decided it had a terrorist connection. But on the other hand, some of the jury might have thought that was going too far and might have been reluctant to convict. Who knows? But it's certainly true to say that the jury didn't know about it, partly because the accused asked the judge not to lift the press blackout. So I could get some of this wrong because I don't practice in England. I try hard to keep up with what's going on in England. I'm constantly fascinated by it because it's more or less the same as our system, but there's some subtle differences, and I've identified some of them here. But just to end by considering what might have happened in Scotland. Well, to give you an example, in Scotland, the Crown can aver in the indictment, the charge sheet, they can allege that the offence was aggravated by, for example, a connection with organised crime. That's become quite a common thing. If you read the papers, you understand why that is. In that case, it goes in the charge sheet, which means that the jury see it, and at the end they're told if you don't believe that it's been proved beyond reasonable doubt that the offence was aggravated by a connection with organised crime, you can delete it. Maybe that's a fairer system, you know. It's hard to imagine, given the circumstances of the Filton 4, it's hard to imagine how any lawyer could argue that it wasn't, you know, serious property damage or that they didn't intend to influence the government. So it seems impossible to think there was any miscarriage of justice on that ground. But in Scotland, you know, in Scotland there are similar aggravations which go in the charge sheet. But we don't have sentencing guidelines which make a terrorist connection an aggravation, so that one wouldn't go on the indictment in Scotland, because in Scotland it doesn't really exist as a concept. Of course, the judge can take the view that it makes it worse because it has a terrorist connection. It's up to the judge. And if the accused doesn't like the fact that the judge took that into account, the accused can appeal. But we don't have an equivalent sentencing guideline or sentencing legislation. So in Scotland, in short, there would be no allegation of a terrorist connection on the indictment, nor would the judge be bound by law to take it into account. But the judge could take it into account. Equally, the notification proceedings under the Counter-Terrorism Act 2008 do apply in Scotland. I've had to deal with a case where they were applied, but the difference in Scotland is that if you were convicted of an offence under the Terrorism Act 2000, most offences, if not all offences under the 2000 Act, required you to be put on the notification requirement register. And if this had been prosecuted in Scotland, these people would not have been subject to the notification proceedings because they were not convicted of a terrorism offence. Whereas in England, if under the Sentencing Act the judge has decided that there's a terrorist connection, then you are put under the notification requirements. So again, another difference. And you know, people are saying 5 years, 6 years is outrageous for it. I don't know. I can't think of a case where there was £1.2 million worth of damage. Maybe it would be in about 5-6 years in Scotland. The only case I thought of, there was a case which Lord Mulholland dealt with in August 2005. Well, it ended then. And 6 cars belonging to prison officers who worked at HMP Addiewell were in duty within the prison at the night shift. And a group of people turned up and basically petrol bombed all the cars, all 6 of them. And they were all damaged beyond repair. The estimate given to the court was £88,000 worth of damage. Now, I think only one of them was convicted of only that offence. The person I was acting for was convicted of that offence plus another one. But in his report, Lord Mulholland stated that if that charge had stood alone, he would have imposed 8 years imprisonment for petrol bombing 6 cars worth 88,000. Now, it was believed that did have a background of serious organised crime. I think it was probably in the indictment. I can't now remember, but undoubtedly that's the view that Lord Mulholland took of it. So 88,000, 8 years, 1.2 million, starting point of 5, going up to 7, and then back down to 6. So maybe it's right to say the sentence in Scotland wouldn't have been that much different. Anyway, that's all I had to say about it. Don't come on and say they never should have got 5. Well, you can, if you say it, I'm not saying whether they should have got 4 years or 5 years and 3 years. I'm really just setting out the appropriate legislative provisions and trying to explain them. Because believe me, I've been a lawyer for a long time and it wasn't as straightforward for me. I had to look into the legislation, so hopefully you find it helpful. If you don't find it helpful, feel free to look at another YouTube channel. Don't come on and give me a stick. I've been getting plenty of it over the last couple of weeks, but I'm a big boy, so I'll stand up to it. Alright, have a good weekend.